who is suspected to have behaved in a manner likely to cause a breach of the peace. These are the things we were running away from, Your Honor, when we enacted Constitution 2010. Therefore, agree with my learned brother here, who described this application in its truest form as incompetent, an abuse of the court process, even if, and I believe they took all the telephones by the gentleman before you, they can still continue and hack them, and that does not require 14 days hacking them. And if there's any
David does not support the holding of these Kenyans, distinguished Kenyans, then there's nothing more. The court has just to discharge them. There's nothing like issue stringent conditions. On what? There are no charges before you. Just a request for the police to spend New Year with them, and they are not their relatives. They are not their friends. They've already wasted a whole day where they could have been doing other things. So once you find that this affidavit, as I'm about to persuade you, discloses no offense, because you're being told they were about to commit offenses against the peace, then Corporal Anthony Kerini, he states, the first and second paragraph is, the first paragraph he says he's competent to swear the affidavit. The second one, I'm investigating offenses of incitement to violence, disobedience of the law, contrary to section 96 of the Penal Code, taking part in unlawful assembly, contrary to section 78(1), as read with section 79 of the Penal Code, creating disturbance in a manner likely to cause a breach of peace, contrary to section 95 of the Penal Code. Then he goes on, so he's investigating, he's not sure, because if he was, he would be saying they committed a breach of the peace, they did A, B, C, D. He could even be saying how they incited violence, but he doesn't say so. He just names the offenses he wishes to investigate. Then he says they were in the Nairobi Central Business District, as though that was a crime.
Offense. What shall follow therein after, if we incarcerate them for 14 days? Who shall be held responsible for that breach? You might also want to consider, Your Honor, whether the facts pleaded in these affidavits and on the face of the application convinces you to admit the application. For example, you are being told, Your Honor, that you incarcerate them because the police want to investigate the content of their funds, which they unlawfully confiscated. One signifies the discontentment Kenyans have. So who is this complainant that his country has been disharmonized? Ni nani ana complain? So, Your Honor, you're being told at paragraph 9 that for interest of justice, I pray that this honorable court to grant 14 days. 14 days, Your Honor, to investigate speculations. 14 days to investigate content that are not within the possession of our clients. Your Honor, as I sum up, I want to invite you to have a look at the judgment in the case of, in the Ms. Ren's application, E014 of 2023, Haji versus Republic. Of most interest is paragraph 10 of that judgment. The judge in that case said, the presumption of innocence also means that the pretrial detention should not constitute punishment.
Of section 36A. And we humbly submit, Your Honor, that section 36A of the Civil Procedure Code places two-tier test in such a motion application. The first tier test, Your Honor, is with the investigation, and the second tier test rests with the Honorable Court. On the first tier test, Your Honor, the prosecution, the investigation, and that is, permit me, Your Honor, to refer you to section 36A, paragraph C, whereby such an application should contain the general inquiries that have been made by the police in relation to the offense and any further inquiries proposed to be made by the police. And in such, Your Honor, the question that begs our attention is whether there are further proposed inquiries to be made before you. And in such, Your Honor, we humbly beg to refer you to paragraphs 4, 5, and 6 of the supporting affidavit of Anthony Kerini, whereby he states, Your Honor, that they intend to subject the mobile phones of the suspect to Communications Authority and to extract WhatsApp, Facebook, X messages, and photographs taken from the respondents. We humbly submit, Your Honor, that such an exercise can be undertaken when the respondents have already been released. The second reason, Your Honor, that you have been told is that they are yet to obtain CCTV footage from the nearby Java. We still submit, Your Honor, that such an exercise of extracting any slides or any CCTV footages can be done when the respondents are being released on bond and or bail. And the final...
In fairness, equity, and when we come to court, we must come to court with clean hands. What is happening to the senator is despicable, deplorable, reflects a banana republic functioning at its worst. Your Honor, Mr. Ndegwa, my friend Mr. Ndegwa, and myself spent about 4 hours at the office of the OCPD in Nairobi. One, we just wanted to see Senator Omutata as his counsel. We were denied that opportunity, although he was at the police station. Secondly, Your Honor, the senator is a sick man, and his brother had the medicines. I saw the medicines with my own eyes. We wanted to make sure that he continues to be alive and in good health. We pleaded with the police, senior police officer was on duty many, many hours. I had even the opportunity to address our learned media on what was going on. I, a client, an advocate, is right to the counsel under the Constitution. Where you deny a client or a suspect medicine as required by the Constitution, there are very clear provisions in the Constitution. One of them, if I may borrow the word, says that a person shall not be denied medicine or treatment at all. He was. Your Honor, we have had enough of this, of what is going on in the country. No wonder that we have a rule of law in the country. Thank you, Honor. The senator was abducted, but now it has been turned into a legal thing. But at the beginning, he was actually abducted. They were all abducted.
The application before me was filed on 31st of December 2024. The same has been filed by the DPP seeking for orders that the 23 respondents who are before this court to be detained for 14 days to enable the applicant, that is the DCI Central Nairobi, to complete investigations. They have relied on the grounds on the face of the application together with the supporting affidavit sworn by Corporal Anthony Kerini. In brief, they state that the 23 respondents were arrested in Nairobi CBD and that they were booked via Central Police Station, that an OB was provided for the same, that the mobile phones of the said suspects were taken and that are to be subjected to Communications Authority of Kenya, that they are to extract messages, WhatsApp messages, Facebook, X messages, together with photos taken that are inciting to members of the public against the state, that they are yet to obtain CCTV footage, record witness statements, and that in the end, should they be released, they'll continue to disrupt peace and tranquility within the country, and that they are a threat of peace and stability. We had many counsel appearing for the respondents. They have given their response. Among them, they have quoted sections of the Constitution on the rights of the accused persons. They have also raised the issue on conditions of the accused persons who have been availed before this court. They have also stated the law on what is to be considered for the grant of bond, which is compelling reasons for the court to consider. They have raised the rights of an accused persons to picket and to hold peaceful demonstrations. They have also raised an issue that the affidavit that is before court does not disclose any offense, that they are mere speculations, that the investigations to be carried out do not require the presence of the accused person, and that the court has the discretion to grant the bail and bond to the accused person, and that the same has not been objected to, that the prosecution have not demonstrated the disharmony or the breach of peace that is being alleged, that the affidavit seeks an omnibus incarceration of all the 23 respondents who are to be held in custody for 14 days pending investigation, that the same is arbitrary and an abuse of the court process, that the investigations are already prejudiced, that court orders were not obtained to extract information from the said phones belonging to the respondents, and that the court has to balance the rights of the accused person while looking at the said application. In my analysis and having heard all the submissions that have been made by the prosecution and the defense, I have considered the law, the issues that have been raised. I have also considered the nature of the offenses that have been stated in the said affidavits. I will agree with the defense that the same are misdemeanors. I have also looked at the said application and the number of days that is being asked for, which is 14 days. The prosecution, in stating, making a request for the said date, has also stated that there are some aspects of the investigations that will not require the presence of the respondents before this court. This has been raised by the respondents' counsel. The issue of the CCTV cameras, recording of witness statements, will not require the presence of the accused persons in custody. More particularly, what has been stated was that the accused person are a threat to breach of peace. Therefore, from the evidence, from the material that has been placed before me and the law, looking at the compelling reasons, the court has looked at what has been submitted and agree with the defense that the court has to balance the rights of the accused person while granting the orders that has been sought. In considering the nature of the cases that the IO wishes to investigate, the court also considered Article 29 of the Constitution, which provides for the rights and freedom of the accused person. It states that every person has a right to freedom and security of person, which includes the right not to be deprived of freedom arbitrarily or without just cause. The same should be done without, if the same is done without trial, the same should not be done without trial except during a state of emergency, in which case detention will be subject to Article 58. Article 24 of the state constitution also on the rights and fundamental freedom on the Bill of Rights shall not be limited except by law. Therefore, in my analysis, so far as the bond and bail is concerned, there must be compelling reasons not to grant the same. The court bond promotes values that underlie the open and democratic society based on human dignity and equality, equity and freedom. It therefore follows that the function of bail is to ensure presence of accused person to attend a trial. Be as it may, the nature of the offenses as stated does not disclose or warrant detention of the respondents. The state have failed to prove that the investigation will call for limitation of respondents' liberty and require them to facilitate or to conduct investigations. However, I would wish to point out that justice demands thorough investigations, and in the end of the day, if investigations reveal that the respondents are not culpable, justice will have been served, and the course of justice therefore will not be a smooth ride. And based on that, I will allow that I'll make the following orders: that the 23 respondents herein will be released on bond. I hereby grant them a bond of Kenya shillings 50,000 with a surety of similar amount each one of them, or a cash bail of 5,000. I will also direct that they report to the investigating body forthwith pending investigations. We'll mention the case after 14 days. With one contact person.
The 14 days here with 20 something.
20?
Kuna 20, 21, 22, 23 na 24 kwa kisasa nakaje 20 on the 22nd.
20?
Tupeane 20.
14 days.
Yes, 20 and 20.
I will pay the 1,000 for him. I am asking on humanitarian grounds that you do review the cash bill, and all of them may be sick. He says that he does not see the challenge in the review. Just that. Just
He's equally your voter. Millionaire long time ago, and now offered. I don't have 5,000 statements. I have to tell you the truth as a Christian. I do not have 5,000 statements. Gonna wave the cash there. Let these young people, they are poor people. They want to hear that word very much.
he means it.
here, and the plea that has been made by counsel for the respondents. I will review the cash bail to 1,000, each one of you. For the respondents, you'll be reminded that you'll be required to attend court as and when you're required to do so. Failure to do that, a warrant of arrest will be issued and other consequences will follow. You promise to attend court? Yes, Counsel.
This has nothing to do with the case. We are grateful for the order that you have granted. Only to recognize the member of parliament that the authority who has come to